Hello, I'm Amy White. I'm an employment solicitor in the employment team at Rix Kay. Today we're going to have a look at the process of running a disciplinary procedure. It's an understatement to say that disciplinary procedures are not fun for any of the parties involved. For employers, they can be stressful and they eat up a lot of management time. Equally, for employees, they can obviously be very distressing and can have serious consequences in terms of future employment. With that in mind, it's really important to ensure that if you're running a disciplinary procedure, the same is proper and as fair as possible. So today we're going to look at some of the common mistakes that employers make when running disciplinary procedures, in hope of ensuring that if you have to run one in future, you don't make those same errors. Employers often want to suspend employees pending a disciplinary procedure. Generally, if the suspension is to ensure that the employer can conduct a thorough and detailed investigation into the allegation that's been made, then that should be fine. The important thing, however, is to ensure that the suspension is paid, is kept as short as possible, and is reviewed throughout. A suspension that's unpaid will look like a disciplinary sanction imposed before the employee has even attended a disciplinary hearing or had a chance to put their case. So make sure that if you do want to suspend an employee, to give you that time to investigate thoroughly and make sure it's paid, kept under review and kept as short as possible. If you receive an allegation of misconduct against one of your employees, it's not enough just to meet with them, ask them a few questions and then impose some degree of sanction. That's not going to be fair. If you receive an allegation of misconduct, you need to dig into it. You need to investigate it and find out if it's got legs. The extent of the investigation you need to carry out is going to be guided by the complexity of the allegation and also its nature. How serious is it? That will determine the extent of the investigation you need to conduct. In terms of methodology, you need to make sure that you're covering all the bases. That might include taking witness statements from people who witnessed the incident, or looking into documentary evidence. You might even view some CCTV. Failing to investigate is a really common mistake, and it will affect the fairness of the procedure all the way through if you don't do that at the outset. A very common error is failing to give the employee in question copies of the evidence that you intend to rely on at the disciplinary hearing before the hearing itself. As you probably know, employees are entitled to receive reasonable notice of a disciplinary hearing. At Rix Kay, we normally recommend 2 full working days' notice. But giving notice isn't sufficient. The notice period is there so that the employee can prepare for the hearing itself. And if they don't get copies of the evidence you're going to be relying on at that hearing, how can they prepare? When you invite the employee to a disciplinary hearing, make sure you enclose with that invitation copies of the evidence you've gathered and will be using against them. That might be witness statements or copies of the documents you've reviewed, maybe even stills of the CCTV you've downloaded. It's common to find that an employer has either not given an employee the opportunity to bring a companion with them to a disciplinary hearing, or has not permitted them to do so when the employee has asked. It's a statutory right for an employee to bring a companion to a disciplinary hearing, and that companion can be either a work colleague or a trade union representative. Finally, another common error that's made when running disciplinary procedures is neglecting to tell the employee what the possible outcome could be when they're invited to the meeting. If you conduct a thorough investigation, you're likely to know what level of misconduct you're dealing with. Is it low level? Is it serious? Or is it the most serious, gross misconduct? Once you've established that, you're likely to have a feel for the likely level of sanction you might impose. For example, low-level misconduct might elicit a first written warning, whereas gross misconduct could result in dismissal, even if it's the first time the employee has been involved in or committed any misconduct. But you need to make sure that you tell the employee about that before the meeting. In the letter inviting them to the disciplinary hearing, set out what the possible outcome might be, so that they know what the consequences of this process are and how serious it is for them. Failing to do so can really affect the fairness of the procedure. As I said at the outset, running a disciplinary procedure is not fun for any of the parties involved, but making sure that the process you use is fair and proper helps to make sure things run smoothly. As always, if you need any help running a disciplinary procedure or with any other aspect of employment law, please don't hesitate to contact the employment team at Rix Kay.